But let me move on. Then there was a statement too by the Attorney General. He speaks about the police abuse of power on roadways, right? And he said, again, I'm quoting, this is something that was in the media recently. This is said to have been relayed during a program, Issues in the News, where the Attorney General is saying that this thing about stopping people and detaining them without cause is a violation of the constitutional rights of the citizens. And when they sue, it is the state that has to pay for the misbehavior and the violation of the law and the abuse of power by the police officers. This is what the Attorney General is reported to have said recently, that it's an abuse of power to just stop people and detain them. And I suspect that given the context, he's talking about people on the road, traffic crime, stopping people, detaining them. And then he's saying that when they sue, the state has to pay, right? Because I suspect in many of these cases, you don't have any difference. And when you talk about the state paying, you're talking about taxpayers like you and me. We are the ones who have to pay for these infringement of people's right by members of the force. And then, I recall that not so well, about 9 years ago or so, there was a ruling which I felt was a landmark ruling by Justice William Ramlal. And that is a matter in which a lawyer who is now a High Court judge was stopped illegally by the police. They claimed that his vehicle was obstructing the traffic. Apparently, he had a breakdown. They claimed that he was obstructing the traffic. Then the mere obstruction turned to a situation where they wanted to search the vehicle, and then he was arrested, taken to Breakdown Police Station where the vehicle was lodged. Search was carried out, and it was a whole unpleasant incident. Now the lawyer sued the police ranks involved. The two ranks involved were sued, and now, of course, you sue the commissioner, you sue the state. And Justice William Ramlal gave a ruling in that matter in October of 2013. And the judge pointed out, the judge is reported to have ruled that under certain specified sections of the Police Act, the police have no powers to stop, search, arrest, and detain any citizen unless the police have reasonable grounds to suspect that prohibited or stolen goods are being carried, unless a person whom the police reasonably suspect of committed an indictable offense will be found, unless the police have credible and reliable information that someone has committed a summary or indictable offense will be found, or unless an indictable offense has been committed in the view and presence of the police. That was the ruling, 2013. So it's very worrying to hear that 2022, no less a person than the Attorney General have to be making remarks that these illegal acts are continuing, and the state is called upon to fork out sums of money to pay, I think, should be damages to these claimants. This is indeed very worrying, and I'm going to address why I believe that is happening. I'm going to address why I believe it is happening. But let me go further. This is about education. Don't worry with what the amphibians and those will come on the stream and say. Don't worry with them. Hear what the law in relation to, and I read it this morning because I remember that when we were trainees in the police training school, these are things you ought to know word for word, verbatim. You ought to know. And this is Section 8 of the Police Act, Chapter 1601, which deals with the police powers to stop, search, and detain aircraft, vessels, vehicles, or persons in certain circumstances. And hear what Section 18 of the Police Act 1601 states. Any member of the force may stop, search, and detain any aircraft, vessel, or vehicle in or upon which there shall be reason to suspect that anything stolen or unlawfully obtained, or having or conveying in any manner anything stolen or unlawfully obtained, or that any person suspected of committed an indictable offense may be found. And he may also stop, search, and detain any person who may be reasonably suspected of having or conveying in any manner anything stolen or unlawfully obtained. Now, this is where the police power to stop, search, and detain is derived. Section 18 of the Police Act 1601. And it says here about reasonableness. Any member of the force may stop, search, and detain any aircraft, vessel, or vehicle in or upon which there shall be reason to suspect that anything stolen or unlawfully obtained can be found. Reasonableness. Reasonableness. So this thing about people just stopping and searching and without any reason, we can't advance any proper reason, is illegal. The court says that. In the ruling handed down by Justice Ramlal in 2013, it says that. And I remember then that it was the general feeling among several persons that having regards to that, something would change for the better. But it would appear that things have continued in the same vein. And just recently, not so long ago, I mean, it was in the media, the traffic chief issued a statement to say that traffic rank should not be stopping people willy-nilly, should not take license, should not be taking people to the station. He spoke about ticketable offenses. If a person is alleged to have committed an offense, you should have a ticket and they go along their way. Some years ago, a commissioner of police made the same statement that police should not be stopping people willy-nilly and tell you about routine check. And you have to have suspicion, reasonable suspicion. That is what the law says. The Home Affairs Minister at the time endorsed that. He too made a statement to say that this type of illegal search should not be taking place. But notwithstanding all of that, statement from the traffic chief recently, statement from a commissioner of police, statement from the Minister of Affairs, this thing has continued. Something must be wrong. And let me say this, when Mr. Attorney General, sir, when you speak about the people stopping and searching, that is not the only illegal act. I can remember not so long ago when I was at the Police Service Commission, I had to engage with an officer from the Attorney General chambers. And I was told, and I knew it, but I was reminded of all the illegal dismissals that were taking place. And let me explain what happens here. And you know, the only person that in the police force is only the commissioner can dismiss from the rank of sergeant down, and the police service commission from the rank of inspector to assistant commissioner. So we talk about these illegal acts. You know who would have perpetrated these acts. And specifically, it's specifically related to cases where a person is charged. A policeman is alleged to have committed an offense. An investigation is done, and I'm talking about criminal offense. An investigation is done, and the person is charged criminally and put before the court. Now, the procedure is that once a person is charged and placed before the court, the person is interdicted from duty. It used to be that they were interdicted and placed on half pay. I understand that there is some school of thought, legal school of thought, that you should not place the person on half pay. The person should continue to benefit from the full salary. I know that that is not happening, but that is another issue. So the person is interdicted once charged and placed on half pay, and the letter of interdiction will say to the person that you're charged with a particular offense and that you are placed on half pay pending the outcome of the charge. Listen to this. The letter of interdiction will say to the person that you are charged, and it spells out the offense that you're charged for, but it goes on to say that you are interdicted from duty pending the outcome of the charge. And what happens here now is that what has been happening in recent times is that even before the outcome of the charge, persons are dismissed. even before. So it's prejudged. There's no longer um, you're innocent until proven guilty. A person is charged, and even before the outcome, the person is dismissed based on the same charge. Nothing new, based on the fact that the person is charged, that person is dismissed. But I was advised, and I know that in all of those cases, once the person's challenged the dismissal, the person's challenged, it is a particular lawyer who was a police. I know him well. I consider him to be a friend. He intervened on my behalf on October the 15th at the Georgia Magistrate Court. Thank you, sir. I did thank you then, and I will always continue to thank you. He has been winning all of those cases because the act of dismissing a person under those circumstances is unlawful, is illegal. You can't tell a man that he is interdicted pending the outcome of the charge, and before the outcome of the charge, the person is dismissed. All of those matters, when challenged, the people win, the state has to pay again. And the important thing here for you to note too is that if a person is dismissed under those or any other circumstances, the court can award damages, but I don't think, and the legal people can jump in on this. The court cannot order you to take back the person. Can't order you to say, well, you must re-employ this person, because I think there's a concept to say that you can't force an unwilling employer to accept a willing employee, something of that nature. So, but what happens is that the persons are compensated, they get damaged, and the damages are awarded to them. Damages in the form of financial award is given to those persons. So I would ask that that be looked into, because that is another area where the state has to pay people being dismissed illegally. And again, I see, the Police Act, or the Police Discipline Act in this case, speaks about a rank can be interdicted pending, I think it might be section 10 of the Police Discipline Act, and this is chapter 17:01, says that a rank can be interdicted pending the outcome of a disciplinary charge. That too has been abused, because I was shocked to discover while I was at the commission, persons are interdicted and they're not charged. An allegation is made against a rank, an investigation is launched, and based on the allegation and the investigation, people are interdicted. That is illegal. Because the act says that you have to be, you can be interdicted pending the outcome of a disciplinary charge. So the person has to be charged first, and once the person is charged, then the person can be interdicted. I remember years ago when I was a young officer in charge of the TSU. I sat there, I went to I became in charge of the TSU, was a deputy superintendent. So when you went to these meetings with all the senior people, as they would say, you have to know your P's and Q's. You sat there, you listen, when the time came for you to report, you report on your area, and that was it. And there was one matter that was being discussed. It was a policewoman, not going to call her name, I don't think, well, she's not longer there, but she was accused of abusing a reporter. This is alleged to have occurred at Brickdam. What happened then, she was charged departmentally, and every time the matter was set for trial, she absented herself, she either reported sick, and she avoided. It was clear that she was avoiding trial. So that matter was being discussed by the commander in a division and the senior officers. And then I asked permission to speak, and permission was granted. And I said, well, if that is the case, I would recommend, sir, respectfully, that she should be interdicted pending the outcome of the charge. And then one of the senior officers actually shouted me down and said, how can you interdict? This is not a criminal matter. This is a departmental matter. I said, well, no, sir. Provisions are made in the Police Discipline Act for a person to be interdicted pending the outcome of a disciplinary charge. They said, no, not a thing like that. Mr. Lewis, who was the commissioner then, sent immediately for the volume containing that. And when he read it, he said, well, little Slow is correct. Let's go ahead and interdict it. I felt very good because, again, it's knowledge. I was reading. I knew that the provisions or that provision was there in the law. And I think that resolved that matter. So the provision is there. for a person to be interdicted pending the outcome of a disciplinary charge. But you cannot and you should not interdict before the person is charged. Now, let me say this further. And again, it's about education, It's about education. It's about passing information, because I am aware that the audience, many policemen, serving policemen, listen. They are sometimes afraid to listen to this live stream, but it's on YouTube. They go in their own time and they listen. So I'm passing on information to them. I am passing on information. So the thing is that once the person is charged, the person can be interdicted pending the outcome. Now, based on a ruling a few years ago, in a particular case, they, outside of interdiction, because it's a question always, members of the public always raise this issue. A man is alleged to have committed an offense, a serious offense. And people talk about this job, or people talking about, especially when it relates to shooting and the type of thing. The person is still on the force, the person is still working. Based on a recent ruling in the High Court, the Commissioner of Police, in the case of Constable to Sergeant, or the Police Service Commission, in the case of Inspector to Assistant Commissioner, can send that person on administrative leave, come off the job until this investigation is finished. That is a ruling that was made, I think, 2 or 3 years ago, and I would urge you to follow it up. And those of you who, I have lots of officers, friends, and even junior ranks will reach out to me. I have the ruling. I have the reference, and you can reach out, and I will provide you with the necessary information so that you can be enlightened. You can know what's going on. And I am always willing to share with you. I have made it clear, and I will say it again, that I don't want anything to do with the current administration, unprofessional as I think they are. I don't want anything to do with them. But when individuals reach out to me, I will provide you with the relevant information, or I will direct you to where you can find the information, right? So I'm saying to you that you can't, and this is for the senior ones, you can't interdict a person without the person in charge. And I'm talking about disciplinary. You can't interdict them without them being charged. You have to charge first. And once they're charged, then Section 10, I think it's 10 of 1701 allows for the person to be interdicted. Of course, the interdiction, if it's from the rank of constable to sergeant, that will be done by the Commissioner of Police. If it's from inspector to assistant commissioner, that has to be done by the Police Service Commissioner. So please, if it is still going on, please correct it, because you're causing the Attorney General to pay, or the state to pay. The Attorney General made the point that the state is made to pay all this money because of the illegal act, and he referred specifically to the stop, search, and detain. But I've expanded because I am saying that these illegal acts occur elsewhere, and it needs to stop.